is Tom Watson. I'm with Wisconsin Lawyers Mutual Insurance Company. We are set up in the back, so come say hello later today if you get a chance. We are in Madison, and as probably all of you know, we have been providing malpractice insurance and risk management services for the last 25 plus years. So why are we talking social media? Well, I think it's because it's part of the landscape now, and it's part of this greater landscape that you all face, where you don't want to face extinction. I heard about the student loan debt, and big firms aren't hiring young associates out of school now the way they used to, and the job prospects are much more difficult than they used to be. So your challenge is, how do I get meaningful employment that pays the bills and that makes me fulfilled and satisfied? And what I find too is that this profession is losing lawyers who eventually get out of the profession, either because they can't make a go of it or it's not as fulfilling as they thought it might be. And so I think social media is part of that whole revolution, if you will, in this particular profession. I've listed some benefits here on this slide, and you know about all these. We talked about them, staying relevant, getting to that large audience, making that connection to a larger audience of potential clients, the immediacy, the real-time nature of it, enhanced consumer interaction. You can reach more people. The old days you had to go to all the bar meetings and the church groups and if you wanted to really get, as a young lawyer, when you wanted to build a client base, you had to, and you still should, by the way, that's a great marketing tool, but in addition, technology allows you to really reach out and touch people, as the old commercial used to say. Ease of use, it's cost effective, easy and fun, and of course it expands very quickly. Those are all great reasons to get involved in social media and really use technology. You want to do it without losing control of your message. You want to make sure you don't create unrealistic client expectations. You want to do it without inadvertently creating a lawyer-client relationship. And you want to do it without running afoul of the rules of professional conduct. That's all kind of obvious stuff, but in some respects it might be easier said than done. When you're out on Facebook or you're blogging, I know the panel was talking a lot about blogging and writing electronic columns and things like that. It's easy to, the line can get blurred very easily, and you can end up putting out advice. There's a big difference between, I'll put it this way, there's a difference between legal information and legal advice. And when you blog or when you see somebody on Facebook and you write a reply or you put a comment in there, it's easy to cross that line from legal information to legal advice, and you can be unwittingly creating a lawyer-client relationship. You can unwittingly put out legal advice to someone who thinks they can rely on it, and believe it or not, that can result in a malpractice claim, even though you really didn't have any formal lawyer-client relationship. We used to call it, before the age of technology really hit us big, we called it cocktail law. You're at a party and somebody asks you a question about their neighbor's fence being on their property, and you kind of give them an answer, and you go back to the bar and get another beer, and next thing you know, this person walks off and says, Attorney Tom Watson told me I could do this, and then they go to court or they do whatever they do, and next thing you know, you've got a lawyer-client relationship when you didn't know it. So that's one of the big dangers I see in blogging and Facebook and even Twitter. When you're putting out commentary, legal commentary, you want to be really careful about putting out legal advice, because number one, you're putting it out there to almost anybody. I mean, the internet still is sort of the wild, wild west, isn't it? You don't know who you're talking to, and therefore you could be giving advice to just about anybody. And there are a lot of ramifications to that, including out-of-state potential clients, states that you're not licensed in, and those sorts of things. Just to give you an idea of what I mean, when you're blogging or when you're responding maybe to somebody's Facebook post, or you got something on your website, obviously somebody in Florida or California or Texas can read your website, can read your Facebook post or your blog. Are you licensed in those states? Maybe not. I wasn't. So if you're responding to them or you're developing some kind of a relationship with them, you got to be careful. And there's some differing ethics opinions about that. Again, I'm not the ethics expert. You could talk to Tim Pierce at the bar about this, but and I don't think there's any opinion in Wisconsin about it yet. But that sort of thing calls into question where are you practicing and who are the clients and where are they coming from. When you use Facebook, again, you might want to use it for professional reasons, and that's fine. But it's so easy to get into that personal stuff, and then there's the politics. There are local issues maybe, and when you start commenting on those things, or again, as I mentioned earlier, legal issues that might come up. Somebody posts a question, and as a lawyer, you want to help, and maybe you feel obligated to respond in some way. And even if you keep it pretty general, I think you still run that risk. I'm not a big fan of just replying to a legal issue sort of out there in the frontier. I think that's not a great idea because your words are your words, and you're tied to them and you're stuck with them forever. And sometimes you think you're not saying much of anything consequential, or you're not saying anything controversial, and next thing you know, somebody's interpreted one way that you didn't expect, and before you know it, you got something you didn't expect. So that's a risk too. I put ignoring the rules of professional conduct. I'm not sure ignoring is so much the problem as maybe not knowing or not being aware of a rule that you might be violating. I'm going to talk a little bit about some of the rules here momentarily. I talked about the unrealistic client expectations, and then there's also the false or misleading communication. I know none of you would purposely do such a thing, but misleading can happen by mistake. I live in the malpractice world, and a lot of malpractice claims are a result of lawyers doing something that they certainly didn't intend. Malpractice claims can happen to really good lawyers, well-intentioned, honest lawyers. So a mistake or putting something out on a social media site that might be misleading or might not be entirely accurate doesn't mean that you are dishonest or you're trying to mislead people. It just means that somebody might have interpreted something differently, or it came out in a way you didn't intend. And so those are some of the dangers. And again, the panel was talking about all the great things you can do with social media, and then here I come, the malpractice guy, kind of putting a damper on things, and I don't mean to, but I think this is all stuff we need to talk about.